That's enough. USDA agents kept trespassing on my farm. Every single month for the next 14 months they would roll through my gate like they owned the place, walk my rows, dig my soil, photograph my ditches, and act as though the deed in my pocket was nothing more than a quaint historical curiosity. I warned them every way the regulations allow. They treated the warnings like junk mail. They had no idea what they were walking into. Let me start from the beginning. March 3, 2023, 6:47 a.m. I was finishing my routine walk of the North 40, the same 40 acres my grandfather took title to in 1938 under the Bankhead-Jones Farm Tenant Act of 1937. The air still carried the bite of late winter, and the ground was firm enough under my boots that each step rang the way it has every dawn for 85 years. This land is not scenery to me. It is sovereignty. Every steel post, every survey monument, every strand of 5-wire barbed fence represents mortgage payments made during the Dust Bowl, during the war, during the farm crisis of the 80s. The original patent signed by Franklin Roosevelt hangs framed above the desk in the farmhouse office. The current deed, Book 47, page 112 at the county courthouse, has been quietly renewed every time the ink started to fade. Nothing about its boundaries has ever been in doubt. That's when I heard the low rumble of government diesels. 3 white Chevrolet Suburbans with U.S. government plates and the gold and green USDA shield on the doors turned off the county road and rolled straight through my open gate without slowing. They stopped in the middle of the service road beside my 1948 Alice Chalmers WD. 8 individuals climbed out wearing the familiar Navy windbreakers of the Natural Resources Conservation Service. The woman in front had the silver oak leaves of a GS-13 stitched to her collar. Her name tape read K. Whitaker, NRCS State Wetland Compliance Coordinator. The others carried soil probes, clipboards, measuring wheels, and a drone case the size of a briefcase. They moved with the calm, practiced efficiency of people who have done this hundreds of times and have never once been told no. I walked toward them at an easy pace, coffee still in my left hand, right hand free the way my father taught me. Morning, folks. You're on private property. State your business. K. Whitaker looked up from her tablet and offered the small, professional smile that every federal field agent learns on day one. Mr. William Caldwell? Kathleen Whitaker, NRCS. We're conducting a routine highly erodible land and wetland conservation compliance spot check authorized under the 2018 Farm Bill. Your parcel was flagged during our annual random selection process. This shouldn't take more than a few hours. I reached into my shirt pocket and unfolded the laminated copy of my deed I have carried since 1994. Ms. Whitaker, this farm has been in continuous compliant production since 1938. We have filed Form AD 1026 every certification period since the program began. Our current conservation plan was signed by your office in June 2021. Under 7 CFR Section 12.5 B. 4. Spot checks on private land require 30 days written notice and opportunity for the producer to accompany. You'll need to conduct any observation from the county road until proper notice is served. Whitaker's smile did not flicker. Mr. Caldwell, the 2018 amendments expanded Emergency Wetland Verification Authority. We're simply confirming that no unreported conversion has occurred since your last certification. Cooperation is strongly encouraged. Behind her, 2 technicians were already unfolding a measuring wheel and walking my winter wheat stubble in a perfect grid. A third had opened the drone case and was attaching bright orange propellers. A fourth was driving a soil probe into the ground every 50 feet, twisting it down 18 inches, pulling it up and bagging the core like evidence. I kept my voice level, the same tone I use when the bank calls about an overdue equipment note. You are currently trespassing on private property. I am instructing you to cease all activities and exit the premises immediately. Whitaker extended a business card with the calm confidence of someone holding 4 aces. Will be completed by noon, Mr. Caldwell. Refusal to allow access can trigger administrative action under 7 CFR Section 12.9. Ineligibility for all USDA benefits until compliance is verified. We'd hate to see that happen to a Century Farm. They stayed exactly 4 hours and 37 minutes. I know because I started the timer on my phone the moment the first Suburban crossed the cattle guard. They flew the drone for 43 minutes, took 312 soil cores, photographed every visible tile inlet, every grassed waterway, every seasonal puddle left by February rain. When they finally packed up, Whitaker handed me a carbon copy of Form NRCS CPA 26 labeled Preliminary Wetland Determination, Potential Violation Pending Further Review. I photographed their boot prints in the soft ground beside the field road. I collected 3 abandoned soil core bags with NRCS evidence labels still attached. I noted vehicle license numbers, employee ID numbers visible on lanyards, and the exact time each person crossed back over my fence line. Back in the farmhouse, I opened the leather-bound logbook that has recorded every government interaction since my grandfather wrote the first entry in 1942. In black ink, I wrote, March 3, 2023, 6:47 to 11:24. 8 NRCS personnel led by K. Whitaker, GS 13, conducted unauthorized entry and wetland delineation activities on parcel 19-2, 84-001, without prior notice or consent. Activities included drone overflight, 312 soil cores, extensive photography. Preliminary technical determination issued alleging possible violation. All individuals advised of trespass and instructed to leave. Boot prints and abandoned evidence collected. Video recorded continuously. That night I scanned everything and emailed copies to our family attorney, Margaret Liu, who has fought USDA appeals since the Reagan administration. Margaret called me back within 20 minutes. Will, they're testing the new enforcement playbook. Document every second. If they come back without notice, we'll have them for criminal trespass and Fourth Amendment violations. Start the paper trail tonight. I already had. They had no idea what they had just walked into. 1 month later they came back, and this time they brought the lie in writing. April 5, 2023, 7:12 a.m. 5 white Suburbans this time, followed by a 4-door pickup pulling a trailer loaded with orange pin flags and a mini excavator on a flatbed. 12 people total. K. Whitaker led again, but now she had company. A certified wetland delineator wearing a vest that read National Wetland Team Washington, D.C., 2 GS-12 soil scientists, and a tall man in a crisp USDA windbreaker whose name tape read R. Hollis, Deputy Administrator, Farm Production and Conservation Business Center. The Deputy Administrator does not normally ride along on spot checks. That should have been my first clue. They did not slow down at the gate. They stopped. One agent hopped out with bolt cutters, and the chain my grandfather welded in 1961 snapped like cheap twine. The pieces are still in an evidence bag in my safe. I was already waiting on the porch, video camera rolling, logbook open, coffee gone cold. Good morning, Ms. Whitaker. You are on camera. You received my certified letter dated March 8 denying consent for entry. Correct. Whitaker produced a manila folder and withdrew my own letter, now covered in yellow highlighter and official stamps. Mr. Caldwell, your letter was forwarded to the National Office for review. The Deputy Administrator is here personally. Your continued refusal to permit access has triggered mandatory compliance review under 7 CFR Section 12.5 C. Emergency Access Provisions. We are exercising statutory authority. I held up the postal receipt with her signature dated March 10th. That section still requires written notice and opportunity to accompany. You provided neither. You just committed criminal trespass under State Penal Code 602 and Federal Tort Claims Trespass. Deputy Administrator Hollis spoke for the first time. His voice carried the calm, flat certainty of someone who has never lost an argument with a farmer. Mr. Caldwell, state trespass statutes do not apply when federal officers are executing duties under the Food Security Act of 1985, as amended. We have lawful authority. They stayed 6 hours and 14 minutes. They planted 112 bright orange possible wetland flags in perfect grids across my best soybean ground. They dug 8 soil pits with the mini excavator, some 5 feet deep, leaving piles of my topsoil like fresh graves. They ran a ground-penetrating radar unit up and down my tile lines. The drone flew for 97 minutes this time. One technician used a handheld spectrometer on every puddle within a half mile of the farmhouse. I walked behind them the entire time, narrating into the camera like a nature documentary. 7:42, Agent Whitaker directing excavation of pit number 3 in the middle of certified HEL-compliant no-till soybean residue. 8:19, Agent Unknown attaching GPS logger to main tile outlet. 9:55, Deputy Administrator Hollis photographing 1945 stock pond, constructed with SCS cost share contract 47 to 112, still on file in your office. At 13:26, Whitaker approached me with a new form. This one hot off a portable printer, NRCS, CPA, 27, Final Technical Determination, converted wetland CW plus 2018. The document declared 38.7 acres of my farm, prior converted cropland, that has been unlawfully maintained since the 1990 baseline. Penalty: immediate ineligibility for all USDA benefits until the acres were restored to 1985 wetland hydrology. I accepted the paper without signing acknowledgement. Ms. Whitaker, you are aware my grandfather received written approval from your agency in 1962 to tile these same acres under cost-share contract, correct? That approval is no longer valid under current policy, she replied. I photographed the form, the bolt cutters, the broken chain, and every orange flags. I later pulled and cataloged by GPS coordinate. That evening, I updated the logbook in the same black ink. April 5, 2023, 7:12 to 13:26. 12 NRCS personnel led by K. Whitaker and Deputy Administrator R. Hollis forcibly entered property by cutting gate destruction, conducted excavation, soil pits, GPR survey, and issued final technical determination alleging 38.7 acres converted wetland in direct contradiction to 1962 SCS Contract 47 to 112. All individuals advised of criminal trespass. Video 6 hours 14 minutes continuous. Evidence cataloged. Margaret Liu filed the emergency appeal with the USDA National Appeals Division that same night and simultaneously filed a federal tort claim, Standard Form 95, for property damage and trespass. Amount claimed, $250,000 actual, $1 million punitive. 10 days later, the Office of General Counsel sent a 2-page denial letter. Claim denied. Entry was lawful under statutory emergency authority. Damage, if any, was de minimis and necessary for compliance verification. I stapled the denial to the growing file. Then I did something they did not expect. I filed a Freedom of Information Act request for every internal email, memorandum, and performance plan mentioning my farm or Operation Clean Sweep for the previous 24 months. The response package arrived on May 3rd. It was 4,187 pages. Page 2114 contained the sentence that changed everything. From Hollis, R. Deputy Administrator, to Whitaker, K. State Compliance Coordinator. Subject: Caldwell Parcel 19-284-001. Let's move this one to the front of the queue. National Office needs a high-profile reclamation success for the IRA funding package. Creative baseline interpretation authorized. Bonus pool tied to reclaimed acres. They weren't enforcing the law. They were manufacturing a violation to justify a budget line item. I printed that email in color, highlighted the word creative, and added it to the evidence binder. They had just handed me the rope, and they were already scheduling the third visit. They stopped pretending to be polite. August 14, 2023, 5:59 a.m. 6 vehicles this time, 4 Suburbans, 1 box truck with a full-size track hoe on a lowboy, and, for the first time, a marked U.S. Marshal Service Tahoe bringing up the rear. 17 souls in total. K. Whitaker was there. R. Hollis was there. A man I had never seen before wore the silver stars of a deputy regional administrator. And now they carried paper. They cut the new chain on my new steel gate, the one I installed after the April visit, and rolled through like a military convoy. The marshal stepped out first, handed me a stapled document still warm from the printer, and spoke the only words he would say all day. Federal Administrative Inspection Warrant, signed 3/14 this morning by Magistrate Judge L. Ramirez, ex parte. Step aside, sir. I took the warrant, started the camera, and began reading aloud for the record. United States District Court, Eastern District of California. Miscellaneous Case 23 MC 00914. Application by Kathleen Whitaker. Supported by affidavit claiming reasonable belief of ongoing wetland conversion and imminent risk of irreparable environmental harm. Warrant authorizes immediate entry, excavation, sampling, and installation of monitoring equipment on Parcel 19-284-001. Effective immediately, expires September 14, 2023. The affidavit was 32 pages of photographs, soil data, and drone imagery, every bit of it collected during the 2 previous trespasses I had already sued over. They stayed 3 full days. They brought the track hoe. They dug 37 test pits, some 8 feet deep, in the middle of my standing corn. They installed 6 piezometer wells with data loggers that blinked red every 10 seconds. They ran ground-penetrating radar for 18 hours straight. They poured blue dye into my tile outlets and waited downstream to see where it emerged, turning my drainage ditches the color of antifreeze for half a mile. I followed them the entire time with 2 cameras, one body-mounted, one on a tripod. Every shovelful, every word, every serial number on every piece of equipment. At 16:42 on the second day, Deputy Administrator Hollis stood in pit number 29 and told the wetland delineator, loud enough for my shotgun mic to catch it crystal clear, mark the hydrology threshold at 28 days. If we need to adjust the 1985 baseline imagery later, we can blame cloud cover on the original slides. National wants this one closed out before the fiscal year. I already had the 1985 slides. Original Kodachrome transparencies from the National Archives, delivered by FedEx the week before. Cloud cover was 0% that day. On the 3rd afternoon, Whitaker handed me NRCS CPA 152, Notice of Violation and Benefit Ineligibility. 41.3 acres now declared converted wetland. Penalty: total loss of eligibility for every USDA program, crop insurance, disaster payments, even conservation cost share, until the land was restored to pre-1985 wetland conditions. Estimated restoration cost quoted by their contractor, $411,000. Civil penalty assessment to follow. I signed nothing. I simply photographed the document, placed it in a fresh manila folder labeled Exhibit K, Fruits of a Legal Search, and added it to the evidence locker. That night I sat at the kitchen table with Margaret Liu and a retired federal judge she brought in as co-counsel. We read the warrant affidavit line by line. Every photograph, every soil pit location, every drone image cited as probable cause had been obtained during the March and April trespasses. The same trespasses the Office of General Counsel had already declared lawful in writing. They had used the fruit of their own illegal searches to obtain a warrant. Margaret smiled the way a wolf smiles. Will, this is Franks versus Delaware on steroids. They lied to a magistrate. We're not just suing for damages now. We're going for suppression, Bivens claims, and criminal referral. August 28, 2023, we filed Caldwell versus Vilsack et al. Case 2:23, CV 01847 in the Eastern District of California. Counts: 1. Fourth Amendment violation, unlawful search. 2. Fifth Amendment regulatory taking without compensation. 3. Federal Tort Claims Act trespass and property damage. 4. Civil rights violations under color of law, 42 U.S.C. Section 1983, Bivens analog. 5. Motion for preliminary injunction and temporary restraining order. We attached the FOIA email about creative baseline interpretation, the video of Hollis instructing the delineator to falsify hydrology numbers, and the OGC denial letter admitting the earlier entries were lawful, creating binding judicial estoppel. September 11, 2023, I filed a separate whistleblower complaint with the USDA Office of Inspector General, Case IG 2023-00914, alleging systemic fraud in Operation Clean Sweep. The OIG hotline operator sounded almost bored until I read her the Hollis quote about adjusting 1985 imagery. Then she asked me to hold while she transferred me to a supervisory special agent. They scheduled an on-site evidence viewing for October 3rd. Meanwhile, the USDA doubled down. On September 29th, they issued a cease and desist farming activity letter on 41 acres, effective immediately. Harvest my corn or face additional $10,000 per day fines. I harvested the corn, under the watchful eye of 2 deputy U.S. Marshals who stood at the end of each row while the combine ran. October 2nd, 2023, the night before the OIG was due to arrive, K. Whitaker's team returned after dark with a restoration contractor and began plugging tile lines with bentonite under generator lights. I met them at the gate with the temporary restraining order Judge Sarah K. Delgado had signed at 4:57 p.m. that same day. The contractor read the order, looked at Whitaker, and started loading his equipment back onto the trailer without a word. Whitaker tried to argue with the marshal who served the TRO. The marshal simply pointed to the signature block and said, "Federal judge says stop. You stop." For the first time in 7 months, they left without digging a single hole. I stood in the dark and listened to their engines fade down the county road. The rope was around their necks now. They just hadn't felt it tighten yet. February 29, 2024, 9 a.m. The USDA Office of Inspector General released Report 2024-03-001 to the public and to every major agricultural newspaper in the country. 187 pages, plus appendices. I printed all of it, 3-hole punched it, and placed it in a black binder labeled simply Receipts. The findings were written in the dry, merciless language only a federal auditor can produce. Finding 1. NRCS personnel systematically omitted the mandatory written notice requirement in 94.2% of all emergency wetland compliance spot checks conducted under Operation Clean Sweep between January 2021 and December 2023. Finding 2. Regional and national performance metrics for FI 2022, FI 2024 tied employee bonuses directly to acres reclaimed, rather than acres accurately verified. Finding 3. Internal communications demonstrate knowing use of unreliable or altered 1985 baseline imagery in at least 312 cases nationwide, including deliberate misclassification of pre-1990 drainage features as post-baseline conversions. Finding 4. Deputy Administrator R. Hollis personally authorized creative interpretive latitude in baseline determinations to meet Inflation Reduction Act wetland restoration funding targets. Finding 5. The Caldwell Farm, Parcel 19-284-001, was designated a priority enforcement action, not for compliance concerns, but to serve as a high-profile reclamation showcase for congressional testimony scheduled April 2024. The report recommended immediate referral of 18 named employees, including K. Whitaker and R. Hollis, to the Department of Justice for criminal prosecution under 18 U.S.C. Section 242, deprivation of rights under color of law, Section 371, conspiracy, and Section 1001, false statements. The same day the report dropped, Secretary Vilsack held a press conference and announced the suspension of Operation Clean Sweep nationwide, pending comprehensive policy review. Cameras caught Whitaker being escorted from the regional headquarters in Portland by 2 plainclothes OIG agents. She was carrying a cardboard box. March 15, 2024. DOJ opened United States v. Whitaker et al. Criminal Case 2:24-CR00421 in the Eastern District of California. Indictment, 36 counts. The Caldwell Farm was listed as Overt Act No. 1. My civil case settled the same week. USDA agreed to pay $4.87 million into the court registry, $2.1 million for crop loss and restoration, $1.3 million for attorney fees, $1.47 million for constitutional violations. They also executed a permanent covenant recorded at the county courthouse. No USDA employee or contractor may enter Parcel 19-284-001 without express written consent of the owner or a warrant issued upon probable cause supported by oath and particularly describing the place to be searched. The covenant runs with the land in perpetuity. But money and covenants were not enough. I wanted them to feel what it is like to have your life's work treated as a line item. April 23, 2024. The U.S. Attorney added a superseding indictment. RICO predicate acts based on a pattern of similar violations against 12 other farmers in 3 states. My evidence binder, now 12 volumes, became Government Exhibit 1. Discovery produced the emails I had only dreamed of. From Hollis to the entire National Wetland Team, February 3, 2023. Remember, the goal is 500,000 reclaimed acres by 2026. If the science doesn't fit the funding, adjust the science. That's why we have interpretive discretion. From Whitaker to Hollis, April 6, 2023, the day after they cut my gate. Caldwell is lawyering up. Recommend we fast-track the warrant before he gets a TRO. I've already drafted the affidavit citing our prior entries as probable cause. They never imagined those messages would be read aloud in open court. June 2024. Judge Delgado granted our motion to suppress every photograph, soil sample, drone image, and field note collected during the March, April, and August trespasses. The warrant itself was declared void ab initio, fruit of the poisonous tree on a scale the Ninth Circuit had never seen. The criminal case against Whitaker, Hollis, and 4 others was assigned to Judge Delgado as a related case. She knew every detail. July 2024. The restoration contractor who plugged my tile lines under generator lights in October filed for Chapter 7 bankruptcy after my lawsuit named him for trespass and property damage. His insurance carrier settled for $187,000 rather than defend a claim involving intentional federal torts. August 2024. Whitaker's husband filed for divorce, citing irreconcilable differences and federal indictment. Hollis's pension was frozen pending forfeiture proceedings. The other 16 defendants started flipping plea agreements in exchange for testimony against the ringleaders. One GS-12 soil scientist cried on the stand while describing how his performance appraisal was tied to wet acres identified instead of accurate acres. September 2024. Jury selection began. The venire was 60% farmers or descendants of farmers. The U.S. Attorney smiled when he saw the panel. I sat in the gallery every day. I wore the same shirt I had worn on March 3, 2023, the one with the faint coffee stain from that first morning. I wanted them to see it. Opening statements lasted 3 hours. The prosecutor used a single slide for the entire presentation. Photograph of my grandfather standing beside his 1938 Ford Ferguson tractor. Deed in hand, 1941. Next to it, the email from Hollis. If the science doesn't fit the funding, adjust the science. The jury was back in 4 hours. Guilty on all counts for every defendant who hadn't already pleaded. Sentencing was set for November 2024. But before the gavel fell, one final piece arrived by courier. A letter on Department of Justice letterhead, signed by the Assistant Attorney General for the Environment and Natural Resources Division. Dear Mr. Caldwell, pursuant to the Victims' Rights Act, you are hereby invited to address the court at sentencing regarding the impact of the defendant's crimes. There is no time limit. I already knew what I would say, and I knew exactly which binder I would bring with me. They thought the story ended when they cut my gate. They were wrong. The story was just beginning. November 15, 2025, 9 a.m. Courtroom 4, Robert T. Matsui Federal Courthouse, Sacramento. The gallery was full of farmers in their Sunday clothes, many wearing the same expression my grandfather wore the day the bank tried to foreclose in 1936. Quiet, patient, and absolutely certain. Deputy Administrator R. Hollis stood first. He had lost 30 pounds since the indictment. His suit hung on him like it belonged to someone else. Judge Sarah K. Delgado looked down from the bench the same way she had looked at me the day she signed my TRO. Calm, deliberate, and finished with nonsense. Mr. Hollis, you were the highest-ranking official charged in this conspiracy. You personally directed the falsification of scientific determinations for budgetary gain. You instructed subordinates to adjust the science when it did not suit the funding. You weaponized the full power of the United States Department of Agriculture against citizens who had broken no law. The sentence of this court is 42 months imprisonment, a fine of $400,000, and forfeiture of all federal retirement benefits accrued during the period of the conspiracy. Hollis did not flinch. He had practiced that blank face in the mirror for months. It didn't matter. The deputy U.S. Marshal was already moving to cuff him. K. Whitaker was next. She still wore the same polite, professional smile she had offered me on March 3, 2023, but it cracked the moment the judge began speaking. Ms. Whitaker, you executed the orders, but you also improved upon them. You cut gates, falsified affidavits, and lied to a magistrate judge at 3:14 in the morning. You turned a conservation program into a criminal enterprise. The sentence of this court is 24 months imprisonment, a fine of $250,000, and permanent disbarment from any federal employment or contract. The smile disappeared. For the first time in 2.5 years, Kathleen Whitaker looked small. 14 additional defendants received sentences ranging from probation with home confinement to 36 months. Every one of them lost their federal pensions. Every one of them was ordered to pay restitution into a fund for the 312 farmers nationwide whose land had been targeted. Then the judge turned to me. Mr. Caldwell, you have the right of allocution. The court will hear you. I walked to the podium carrying only one thing. The original leather-bound logbook my grandfather started in 1942. I laid it open to the page dated March 3, 2023. Your Honor, this book has recorded every government visit to our farm for 83 years. Most entries are short. SCS agent checked terraces. Approved. FSA loan officer verified acreage. Approved. Until 2023, every single entry ended with the word, approved. I turned the page. Then came March 3rd. The entry is longer. It ends with the words trespass, warned, refused to leave. Every entry after that is the same until the day Your Honor signed the restraining order. I closed the book. These defendants did not just trespass on my land. They trespassed on the idea that a man's deed and his word still mean something in this country. They thought a budget target was more important than 4 generations of sweat in that soil. They were wrong. And today the United States government has admitted they were wrong in the only language it truly understands. Prison cells, forfeited pensions, and receipts. I stepped back. The judge nodded once. Thank you, Mr. Caldwell. The court has nothing further. 6 months later, the final numbers were in. Total restitution paid to affected farmers. $18.4 million. My share after taxes and restoration. Enough to buy the neighboring quarter section and retire every note on the place. Operation Clean Sweep. Permanently enjoined by consent decree. New USDA national policy, effective January 1, 2026. No entry onto private agricultural land without 30 days written notice, landowner accompaniment, body camera footage, and pre-approved search plan. Violations now trigger automatic Office of Inspector General investigation and personal liability for the entering employee. K. Whitaker served 19 months of her 24 at FCI Dublin and was released to a halfway house in Billings, Montana. She works the night shift at a 24-hour diner off I-90. Regulars say she never smiles anymore. R. Hollis served 36 months at FCI Lompoc and lost everything. Pension, house in Fairfax, marriage, reputation. He was last applied for a position as a night janitor at a community college and was turned down because of the felony conviction. The covenant I forced USDA to record at the county courthouse now sits in Book 4129, page 1187, directly beneath my grandfather's 1938 patent. It runs with the land forever. Every sunrise I walk the same rows my grandfather walked in 1938. The soil is healed. The tile lines run clear. The wheat stands tall and golden under a sky no agency can regulate. They kept trespassing on my farm. They ignored every warning, every certified letter, every court order until the courts ran out of patience. Now they are paying the price. Financially, professionally, personally, and permanently. Justice served.